Hey, everybody, and welcome back to the Legal Weekly Wine, where the H is optional, and we discuss the week's hottest legal topics. The Supreme Court just dropped almost all of their cases on one day and then a second day. So we have been waiting as the final decisions have been coming down, and they sure came down in this last week. Today, we are going to talk about one of the last decisions that was released. This was on June 27th of 2025, and the official title is Trump versus CASA or CASA. I'm not entirely sure how to pronounce it, but this is the Birthright Citizenship case. We've all been waiting on edge, at least we have, with regard to this case and what the Supreme Court would decide. And in a way, it's been a letdown of the central idea of what the U.S. thought the case was about is birthright citizenship. Does it include those who were born here, even if they were brought illegally into if the parents were brought illegally into the United States? So that issue was put on hold and not decided, but another issue was sort of decided. So what we're going to do is we're going to break down this case, the legal ideas, the legal holdings, the dissents in this case, to give a little bit better understanding of what happened, what didn't happen in the case, and what's next regarding birthright citizenship. So with all of that, stay tuned with us. I'm Virginia Tarani. I am the owner and attorney of Tarani Law, LLC. We're based in Maryland, covering Maryland, Virginia, and D.C. And we've got with us our expert, our resident expert in all things Constitution, constitutional law, the amending process, and the founding of our country. So this is Dr. John Vial, who's my co-host. He's the Dean of the Honors College at Middle Tennessee State University. Welcome.
Good to be here.
It is. So we're gonna toast to this podcast again. Dr. Vial, I think you've brought your handy water.
Yes.
Okay.
H2O. Yeah,
yes.
Not just any water. This is H2O.
H2O.
Yeah.
I've brought the fizzy water again. This is a nod to our normal wine, but not quite wine itself. So I have got the sparkling apple of the Izzy brand, which tastes a lot like cider, a lot like alcoholic cider or the sparkling non-alcoholic cider that a lot of kids drink for New Year's. So that's what I've got. It's quite delightful. Cheers, Dr. Vial, to this podcast and our crazy discussion. Okay, so to start off, Dr. Vial, were you as disappointed as I was in the actual holding of this case?
Well, am I disappointed? I wasn't surprised. And I will say that the issue that was decided is itself a very consequential issue.
Mm-hmm.
But one could argue this is a little bit like rearranging the deck chairs as the Titanic sinks by focusing on the power of district courts to issue injunctions rather than focusing on the main issue.
Right.
The issue, what's happened here is that President Trump has issued an executive order which basically says if you're born in the United States and neither your mother nor your father is a U.S. citizen, then you're not a citizen. And if we were starting from scratch, one could make an argument from that, but we're not starting from scratch. In 1857, the Supreme Court, in one of the most notorious decisions in its history, Dred Scott versus Sanford, decided that African Americans were not and could not be citizens, even if they were brought here, if they were born to people who had been brought here as slaves, they were not citizens. And when the 14th Amendment was adopted, the very first section says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and other states as well. And so, in my judgment, particularly as one who really reveres and concentrates on words, the words are clear. All persons. There's one section that requires some explanation, but all persons born or naturalized in the United States, and then the qualifier and subject to the jurisdiction thereof are citizens. So if you're born here, whether your parents were here legally or not, you're a citizen. 99 out of 100 or better scholars and judges are going to tell you that. And in this
Right.
case, three, I think they were largely pregnant women who were non citizens, bring a case to the court and say, we want to make sure that our child is born,
A
if
citizen.
they're born here, that they're a citizen. And three judges all agreed that the issue was so clear constitutionally that this order should apply not simply to the parties that were involved, but to universally across the United States. And in this case, that's fairly important because
Yes.
otherwise we could be in a situation where one state doesn't recognize you as a citizen because you were and will not issue you birth certificates
Right.
because you were born there and another state would. So we're going to have to sort out, well, which state were you born and where were you born
Right.
for something that I think is just, 99% obvious. Now, that little phrase, I do want to bring that in,
Hmm.
subject to the jurisdiction thereof. We
Right.
know in the debates what that means. It means if you're a foreign diplomat and you come to the United States as an ambassador or a similar capacity, and you have a child born here, your child is not a U.S. citizen because you're here as a representative of a foreign country doing
Right.
that job. We're not going to penalize you if that's what people would consider it by making your children citizens. Uh, did it apply to Chinese who were born in the United States of non-U.S. citizens? Yes. Supreme
Right.
Court has a precedent which establishes that. It's been established in American law for probably close to 125 to 150 years. And I don't think there's any really question as to this is an unconstitutional executive order.
So
Now,
why
that
didn't yeah, this in my mind, especially as an attorney, this has become a very procedural issue in the case
absolutely.
rather than one based on subject matter. So what we have here is a very limited question, and the court is saying the question before us is only related to the injunction itself.
Okay. And the reason for that is that the president himself and his
Mhm.
lawyers did not want to argue the basic issue. They know good and well, in my judgment, that what they're trying to do is harass people. It's unconstitutional. They don't want it, so they didn't raise that particular issue. Now, why the plaintiffs weren't able to get that out, I'm not really sure.
Right. And
And
it is odd because the only issue that went up is whether the universal
right,
preliminary injunction against enforcing the executive order was legal, was
right,
appropriate authority
and
by a federal district court.
And this, in and of itself, is a consequential issue.
Yes.
And it's become more so over the past 20 years, in part because presidents, particularly Trump, are increasingly relying on executive orders.
To
And many of
make
them
law.
seem, right, and many of them seem on their face to be unconstitutional. But both, Biden, Obama, Trump, all of them have faced situations where a single U.S. district court has issued an injunction, whether it has to deal with illegal immigrants
Right.
or student loans or any number of things, many of which I don't think the president should be issuing executive orders. I think it ought to come through Congress.
Agreed.
But but we are in a situation where what happens is what we call judge or forum shopping. We know that in certain districts, now many districts, there are 94 districts of U.S. district courts in the United States, and many of them have multiple judges. But some of them have a single judge because it's a
Yes.
relatively sparsely populated area. And after a couple of years, you can figure out whether a judge is largely conservative or liberal. And as a consequence, you can go out and file a suit in an area where you think, in this case, a very liberal judge is going to vote to uphold immigrant rights, or a conservative judge, when Biden and Obama were president, who's almost surely going to strike down something that they've done on Obamacare or DACA or something similar. So it's a legitimate question as to what the scope of the remedy should be.
Right.
And what Amy Coney Barrett writes is she does not think this is called, so there's the Constitution gives jurisdiction to courts in cases in law and equity.
Right.
Law usually involves a fine, a jail sentence, something like that. Equity deals with more flexible remedies. And so the question, as she sees it, is at the time of the founding, were courts allowed to issue equitable decrees that applied beyond the individual parties
Right.
to the nation as a whole? And she concludes that they did not, and she backs it up. And here's where it becomes questionable. Here's where we get to the Declaration of Independence. We're back to the Declaration. It's questionable because she says the main precedents we have are from England. And in
Right.
England, a single judge could not issue a decree against a king. Well, we don't have a king. Or we didn't until the last
Exactly.
election. Maybe things have changed.
Right. And is that the implication that she's setting up?
Right. In other words, her view is we basically have to follow English precedents, even though we set up a tripartite system. We don't have parliamentary sovereignty. We don't have a hereditary king. But and now that's not the only evidence that she gives. She also argues that throughout American history, courts rarely did this until the last 50 years or so.
Right.
Now it's become increasingly common. But there is something of a problem if you think of how many hundreds of judges there are, and you think that you can sort of shop for judges, and then everybody, if every order that a president gives can be stymied by a single court, that's not very effective executive administration. So
But
that is a valid point.
And I agree that's I agree it's a valid point, but at the same time, what the effect of this ruling is that
it's disastrous.
The only way to stop a presidential executive order is essentially for someone in all of these 93, 96 jurisdictions. 94 jurisdictions that they will now have to find plaintiffs that are similar and immediately bring the case before each of these 94 districts.
The court does, and here's where the lawyer is going to help, okay, the academician. The court does suggest that these cases might be brought as so-called class action suits, where you find a party that is representative of a much larger class and you file a suit. Now, I'm not intimately familiar, but I know there's a set of rules that make these cases harder to bring.
Yes.
And they tend to be more expensive.
Very
But
much.
there's in some parts of the decision, particularly Justice Kavanaugh, he basically suggests there's another alternative here. And if it comes to us, we have to do our due diligence and make sure that we give the decisions in a timely fashion.
Then that's what people need to do.
I think the ACLU is among those who have already filed such class action suits. It tends, again, the problem with it, particularly in a case like this, is the people who are most affected are probably least financially able, and maybe in terms of literacy and education and other positions, they're not as well equipped to file these suits as they might be in other cases.
Well, and we have two additional problems. One is timing. Is by the time we get through all of these cases, actually file something in the right court, in the right time, then try to get it up on appeal to the courts of appeal, then try to get it up to the Supreme Court. Well, they have been deported in the meantime. Their actual case will not be heard within the timely manner.
Well, I'm not sure necessarily that these people would be deported, but they could be.
They could be.
if they're not considered to be citizens at all, then possibly they could.
Well, and what I'm finding in my area, I do a lot of civil law, but I do some criminal law, and we as attorneys speak, talk and have forums, et cetera. And what we're finding in our area, I don't do immigration law, but it's still impacting me and my practice, where a lot of people I speak with, they don't want to go to court. They don't want their names.
By the way, we have a podcast on this.
Yes.
With an immigration lawyer. So if anybody is interested, and I know a lot of people are, they ought to go back and listen to this interview with your very well-educated friend.
Absolutely. It's Abbas Sadiq of Sadiq Law Group, and we did 2 podcasts with him. So do go back and check those out, where we do he answers a lot more of our immigration questions. But ultimately what we're finding is they don't want to come forward and put their name on anything that would be filed in court, because what they're saying is, well, I'm identifying myself as an illegal immigrant. I'm putting my name, I'm having to put my address. They can now come and find me and deport me, even if I'm part of this case. And by the time it gets to me, I'm gone. I don't have any more, jurisdiction is gone because I'm no longer here.
Well, one of the sad things about the last 2 days of the court session is, up to this point, they've had a fair number of unanimous and decisions, and they've had decisions that didn't necessarily follow the ideological 6-3. On this day, almost every case was a 6-3 case.
Yes.
And they split, and
by
the
party.
question that the 6 conservatives, 3 of whom have been appointed, so-called conservatives, that have been appointed by Trump, with 3 others. In this case, all 6, sided with the president, if you want to view it that way, and the 3 more liberal justices in the other direction. It's the question that it raises. We've talked about this before. The ethics of the court have already been called into question by gifts that the judges have taken, and by what appear to be over ideological decisions. And I think the question a lot of people are saying is, these cases, these injunctions were being raised during the Biden administration, during the Biden and Obama administrations. Why didn't you issue this decision then? Now, in fairness, this decision will presumably apply to future presidents. But there were very sharp dissents in this case. Justice Sotomayor wrote a very long dissent. And in my judgment, Justice Barrett, who I generally respect, she wrote a very biting majority decision. And I can sort of see why when I read Justice Jackson's dissent, because in my judgment, it's a very articulate decision in which he essentially, judges are supposed to follow, and this is what, Barrett would say, we have to be very careful about process and about procedures. And just because there's a wrong doesn't always mean that there's a remedy. Marbury versus Madison, the classic case involving judicial review, the court says, yes, this man deserves a commission, but we can't give it to him. And that's basically her opinion. And the judges in dissent are saying, get your hand out of the sand and look at what's really happening here. Here's somebody who clearly seems to be violating the actual text of the Constitution, and you're focusing on a technicality.
Exactly.
So it's a very, very good repartee in one sense, despite a little bit of nastiness here, sort of condescension, I think, particularly on Barrett's part. But, well worth reading if you don't mind reading 119 pages of legalese.
Yes, it was quite long, as were
Which
the
for
others.
me is a treat, but not for everyone, I realize.
Exactly. But I think, and let me make sure, did all 3 of the dissenting justices write their own opinion, or was it
I don't believe so. I believe it's just, my recollection is it's just Sotomayor and Jackson.
Ketanji Jackson.
And again, Sotomayor's is the longest, but in my judgment, Sotomayor is joined by Kagan and Jackson,
Right.
and then Jackson files her own dissent. I personally think the best written and the most sort of what uh, ideologically principled one is Justice Jackson's argument. I was very pleased with. She writes very well. It reminded me of Justice Jackson's opinion in West Virginia State Board of Education versus Barnett.
And remind us what
Excellent case.
that is. What
Yeah,
is
the
that West
flags,
Virginia
right,
case?
where he decided that, a state could not force, in this case, Jehovah's Witnesses, to salute a flag in school because it was against their conscience, their religious rights.
So with this, let's talk a little bit more about Jackson's dissent, Justice Ketanji
Okay.
Jackson's dissent. Is there anything in there where she believes they can take up and a justification of taking up the actual issue of birthright citizenship rather
Well,
than this procedural technicality?
well, again, I think the main argument that she and Sotomayor make, and Sotomayor in some ways might make it better, is that, you're trying to apply a principle from what judges could do against a king who served for life as opposed to a president who is elected and is accountable to the people. So I think that's the main legal argument that is made. But along with that, in Jackson's decision is sort of this. In fact, she says, I've noticed. I don't remember these particular words being used in a dissent, but she says, with deep disillusionment, I dissent. And it's like, this is she right. She says the legalese is a smokescreen. We should be dealing with the major issue, and I think the court could now. Barrett's argument is the answer to a lawless president is not a lawless court. We have to dot our I's and cross our T's. But Jackson is I mean, the dissenters are very clear that if this case gets to the court on the merits of citizenship, we know how they're going to vote. Now, the question is, will there be at least two others on the court who will join them? And I think the answer is probably yes. And one might argue, and in fact, Trump may have gotten himself in a little box here because Trump came out immediately and began praising the justices.
Oh, he had a press conference.
Right, for doing, great win. Well, it's a technical win, and it may be that they're sort of keeping their powder dry, that they're now, will it come at the expense of some newborn children? Yes.
Yes.
But if they subsequently, a majority of the court, particularly if it's a large majority, disagree with Trump, then it gives them considerable credibility. We're not out to get Trump. We rule with him against universal injunctions, but that doesn't mean that we're always going to accept his interpretation of the Constitution.
Well, and let me ask this, where he has been saying, "Oh, this is a great win," and you're saying, yes, they've ruled in his favor. But what kind of ruling is a holding that says, well, let me
Likely?
make sure, yes, that it
Yes.
is likely, right? That it is likely that, let me make sure, yes, it is.
Yeah, no, I've circled that too.
Universal injunctions likely exceed the equitable authority that Congress has given to federal courts. That's not a decision.
Well, I think it's sort of mixing two things. Before you give a preliminary injunction, there has to be a strong likelihood that the law is unconstitutional. I think she sort of mixed the two. But it does add an element of ambiguity in the decision that you sort of scratch your head and say, it is, because her decision is pretty clear. She doesn't think courts have the right to do this, or
But
district courts.
exactly, but that's not the holding language. It's almost
No,
as if,
I'm aware.
as if the question was presented as, can federal courts, district federal courts issue universal injunctions? And what the wording is maybe.
Likely. Yeah.
Probably. Likely. I mean, let's use the real synonyms, right? Likely
Yeah.
is maybe more than possible.
Yeah.
Probably. I would use probably as the most similar synonym in the legal field, but it's not a full holding that would be a yes or no. So to
Well, it
me,
reads like despite that language, it reads like it's very clear that she's very clear that they don't have the power. But again, that word threw me. I've read it a couple times
oh,
trying
it's
to.
terrible. I mean, let's put this in more cases. If we actually get to the merits of the birthright citizenship claim, do children born in the United
You're
States
likely a citizen. Yeah.
maybe, likely, probably. What? It's one of
Yep.
the worst holdings I've ever seen in constitutional law because it's not a clear directive. And if I were into this particular type of law in terms of my day-to-day activities and actually filing lawsuits regarding them, one of the first questions I would bring up is, well, is it or is it not? Let's actually decide it. And I don't think that this issue has been fully decided on the merits of even the injunctions. And as a district court judge, I would probably issue a decision of, well, they only said
Saying that it's
likely.
likely that
I
the
don't
court.
believe that it is. They only said that it's likely. So here's my decision. Here's my universal injunction, and off it goes. The language, like you said, it threw me. And I'm still scratching my head over this, wonderful win that Trump had. That seems like, maybe.
Yeah.
So, all right. So that's what's happening in this case. What everybody is claiming is the birthright citizenship case, which actually is a preliminary injunction case. That's what this really is. So we're waiting to see who brings forth the next lawsuits with regard to the merits of birthright citizenship, whether they're taken up in each of the jurisdictions, how they're put together, including through this class action system, and how quickly it goes through and up to the Supreme Court. So we are still holding and pending the actual merits of birthright citizenship.
And I don't think the court addresses it, but it is typical. It's not atypical in American law to have circuit courts that have come to different agreements and where you
Yes.
actually have differential application of the law.
It's
And
called
I'm
a
not sure.
circuit split.
Right. And they're the occasions where the court most frequently intervenes. And one of the reasons that you might question whether the court should have intervened here is that all three courts that decided in the same direction. They all
Yes.
decided in favor of the plaintiffs. And so one could argue that the court is, although it's saying that it's being, it's trying to limit its own power, one could say, well, you really didn't need to intervene here until you got a district judge that said otherwise.
Exactly.
And I don't think you're going to find many district judges who will.
I don't think so either. And many of the judges who have been deciding these issues have said that, it's unquestionable, that this is very clear. It's a clear constitutional right for those born. Trump's executive order seems very clear in its refusal to follow the law that is in our Constitution through this amendment. So we'll see what happens. Stay tuned with us on this and what happens next. We are actively reviewing and watching for these decisions and for these cases, and we will keep you updated. And next time, I'm not sure which order we're posting these, but it may be before or after the Declaration of Independence podcast that we have with regard to the 4th of July. And then we will also be covering Mahmoud versus Taylor, which is the LGBTQ plus case from the Supreme Court, one of the ones that they dropped at the end, as to whether people have the option in school to opt out of certain curriculums, especially with regard to their religious views. So that's one of the cases we'll be considering and reviewing with you. And then we'll get to some more. The Supreme Court had quite a few, so we will review those in our Supreme Court review. Don't forget to go to www.thelawunscripted.com, especially if you're studying for the bar this summer. We have 8 different courses that we review, which are the main courses covered by the Universal Bar Exam, so the UBE. These are the courses done through the multiple choice part of the exam, and also then covered in some of your essay questions. So if you're struggling with some of the topics like constitutional law, civil law, torts, etc., please check out those courses. They're taught in, we even have hypotheticals where we put together our own ideas of what a test question would be and see if you can do well. See if you got all the points and the issues that we point out, and then go through our lecture series, our video review series. And if you don't do that, check out our merchandise. We have quite a few legal hilarities. I don't know if that's a word, but we have them. Funny quotes and sayings that go on t-shirts and coffee tumblers. So if you're looking for some fun and some humor amidst all of this chaos in the courts, certainly look for it there. And we will catch you next time on the Legal Weekly Wine.